Welcome to the Superior Court of California. This video will give you a brief overview of the process of an eviction case, also known as an unlawful detainer. In addition, you will learn about mediation, which may help you resolve your eviction case without a trial. An eviction case is a lawsuit to force someone to move out of a property. It is most often filed by a landlord against a tenant, but it may also be filed by a tenant against a subtenant, or by someone that owns the property because of a loan foreclosure. In this video, a landlord means anyone filing an eviction case, and a tenant means anyone who is occupying the property. If the landlord wins the eviction case, the tenant must move out, or may be physically removed by the sheriff. Also, the tenant may be required to pay the landlord money. If the tenant wins, the tenant may stay in the property and may be entitled to repairs or a rent reduction. Eviction cases have many strict rules and legal requirements, and they move very quickly. All parties to the case must respond without delay and take very specific actions. Because of these strict rules, it is easy to miss the deadlines or make mistakes in the process or the paperwork. These mistakes can cause delay or cause either party to lose when they might otherwise win. It is very important that you talk to a lawyer or your court self-help center or advisory services to learn about the law, your rights, and your options. This video can help you understand what is involved in an eviction case, and it identifies resources to help you. These resources can also help you if the eviction case is the result of a foreclosure on a property. Generally, a landlord may be able to evict a tenant who is behind on the rent, damages the property, interferes with the rights of other tenants or neighbors, breaks the law, or breaks the lease or rental agreement in some other way. In most cities, the landlord can also evict the tenant if the tenant stays after the lease is up, or if the landlord cancels the rental agreement. But some cities have rent control laws that limit a landlord's ability to evict a tenant. Also, if your case involves a mobile home, RV park, or public housing like Section 8, different rules may apply. Other rules may also apply if the property is or was in foreclosure. Make sure you research the law that applies to your specific case, because it can affect your rights and responsibilities in an eviction case. There are several steps to an eviction. The landlord gives the tenant written notice. First, the landlord must give the tenant a written notice telling the tenant what is required. There are different types of notices with strict legal requirements. If the landlord doesn't use the right type of notice, fill it out correctly, and give it to the tenant properly, the landlord may lose the eviction. The landlord files and serves the unlawful detainer. The tenant doesn't do what the notice asks in the time provided. The landlord must file court papers and pay a court fee to evict the tenant. A landlord cannot legally evict a tenant without filing an unlawful detainer case in court and getting a judgment for eviction. After the case is filed, the landlord must let the tenant know about the lawsuit in the proper legal way. This is called service. There are different ways to serve the other side, and the rules are very strict. The tenant files and serves response. Once served, the tenant has 5 days to respond by filing papers with the court and serving them on the landlord. The most common response that tenants file is called answer. If the tenant doesn't file papers on time, the landlord can win the case by default, and there will be no trial. This means that the tenant will not get a chance to present his or her side to a judge. A trial is scheduled. If the tenant files an answer, the landlord or tenant must ask the court to schedule a trial date. Either side can request a jury trial if they want one, but the party who requests a jury is required to pay the jury fees to the court. If a trial is requested, the court will send the landlord and tenant a notice of the trial date. The trial must be held within 20 days from the date it is requested. The parties prepare for court. To prepare for your case, be sure to research and understand the law in your case. Have the rental agreements, notices, rent receipts, photos, or any other pieces of evidence ready. Talk to any witnesses and make sure they will come to your hearing. Go to the courthouse and watch an unlawful detainer trial. The trial is held. The landlord and tenant should attend the trial, even if they have filed papers with the court. If either party does not attend and present evidence, the court may decide the case against them. Presenting evidence at trial is complicated and beyond the scope of this video. Other resources identified in this video can help you present your case at trial. If you are not completely comfortable speaking and understanding English, bring your own interpreter. The court will probably not be able to provide one for you, so it's your responsibility to bring someone who is qualified to interpret for you. This is your only chance, and you want to make sure to understand everything that is said and be able to present your case. The court decides the case. If the tenant wins the case, he or she may stay in the property. Also, the landlord may be required to make repairs, adjust the rent, or pay the tenant's legal costs. If the landlord wins the case, the tenant may be forced to leave the property and pay back rent and the landlord's legal costs. The court may issue an order called a writ that tells the sheriff to physically remove the tenant from the property. In some cases, the tenant can request a stay of execution or a postponement of this order, which can delay the eviction. If everything is done properly at every step and both sides participate in the court process, an eviction case takes about 30 days from when the landlord files papers in court. If the tenant does not respond to the lawsuit, he or she may have to move out in as little as 14 days. There can be delays due to procedural mistakes, or if the tenant loses and requests more time to move out. An eviction case becomes public record 60 days after the case is filed. This means that someone could do a search of public records, find the eviction case, and see what happened on it. Because future landlords can get this information, an eviction case may make it more difficult for a tenant to rent in the future. If the landlord wins the eviction case, either because the tenant does not answer or because the tenant answers and loses, the judgment for eviction may appear on the tenant's credit report. This could make it hard for the tenant to rent again. If the tenant wins after a trial, or if both sides reach a solution by written agreement, the eviction case usually will not show on the tenant's credit report. Mediation is an alternative to going to court or having a judge decide your eviction case. It can help the landlord and tenant avoid the disadvantages of eviction cases. An eviction case is also known as an unlawful detainer. Mediation can be a very good choice for landlords and tenants who have a dispute. It may help you get a better outcome more quickly and less expensively than the court eviction process. In mediation, both sides meet with a neutral person who is specially trained to help people resolve their disputes. Everyone works together to reach an agreement instead of having the judge or jury make a decision. The mediator will not force you to reach an agreement. Whether you decide to resolve your dispute and how you resolve it is up to you. If you can't settle, you can still have the judge or jury decide. There's nothing to lose by trying mediation, and there is a lot to gain. Whether you are the landlord or the tenant, there are a lot of reasons why it is a good idea to mediate your dispute. Many people are more satisfied with the process and results of mediation than with a court hearing. Eviction trials are difficult to properly handle without a lawyer. You need to know the law and follow the rules of evidence. In mediation, you are not limited by the rules of evidence and other strict legal requirements. Mediation allows you to talk about other issues that may not be directly related to the law, but are very important to you and how you feel about the dispute. Both sides must agree on the outcome in mediation so it is acceptable to all parties involved. These agreements are often more likely to be followed than a decision by a judge. If the landlord and tenant settle the eviction case through mediation with a written settlement agreement, the case usually will not appear on the tenant's credit report, even if the tenant agrees to move out or pay the landlord money. But the agreement may expressly state that the eviction will be reported on the tenant's credit report. Depending on what is important to you, you may settle your eviction disputes in many different ways. For example, you may agree that the tenant may continue to live in the property. The tenant will move out of the property on an agreed date and leave the property in good condition. The tenant will make back rent payments to the landlord. The landlord will make repairs to the property. A judgment will not be entered against the tenant if the tenant complies with the agreement. The eviction case will not appear on the tenant's credit report. You can go to mediation anytime you are having difficulty resolving a dispute. If you are writing a letter to the other side about a problem regarding the property, or sending or responding to an eviction notice, consider asking the other party to mediate the dispute. Some mediators will call the other party for you, explain mediation to them, and encourage them to mediate your dispute. You can ask the other side to mediate your dispute before or after an eviction case is filed. Preparing for a mediation is a lot like preparing for your trial. It is important to identify and organize the facts that are relevant to your dispute and understand the law that applies to your case. Be sure to know about the facts that support the other party, not just those that support you. If you are going to mediation before trial or instead of trial, there are some other things you should do to prepare. Be realistic about how the judge would decide your case if you had to go to court. If possible, talk with a lawyer who can give you advice about how a judge would decide. Think about whether you or the other party is angry or has hurt feelings, and why. Consider what you and the other party would really like to accomplish. Think about whether something beside or in addition to staying in or moving out of the property might help to satisfy you or the other party. Come up with a list of alternatives that both parties might agree on to avoid a trial, delays, and the possibility of losing or not collecting any money owed to you if you win. At the mediation session, be sure to present your side of the dispute clearly and listen carefully to the other party's point of view. Make suggestions for how to settle the dispute, but also listen openly to other ideas. Remember that mediation is about give and take. Everyone has their own point of view. Although you may feel like yours is 100% right, you may learn things that help you better understand the problem and resolve the dispute. If you settle your dispute in mediation, the mediator may encourage or help you to prepare a written agreement. This document should clearly explain what everyone has agreed to do. If the landlord hasn't filed an eviction yet, a court case usually won't be filed or become a court order unless someone does not do what they agreed. But if somebody does not do what they agreed, a case may be filed and the agreement may be enforced by the court. If the landlord has already filed an eviction case with the court, your agreement may be documented on a court form called a stipulation. The agreement or stipulation may be filed with the court and become an enforceable court order right away. Or you may decide that the stipulation will only be filed and become a court order if someone breaks the agreement. Many counties have nonprofit dispute resolution programs that provide free or low-cost mediation before or after an eviction is filed. To find a program near you, ask your court for a list of mediation programs in your area. Some courts offer free or low-cost mediation, either before the trial or on the day of the trial. Private mediators are available in many communities, and they often advertise in the yellow pages or newspapers or on the internet. Private mediators' backgrounds and fees vary considerably, so be sure to ask. For more information about eviction cases, ask your local court or law library, or go to www.courts.ca.gov/self-help. For more information about mediation, go to www.courts.ca.gov/programs/ADR. To find a private attorney who handles unlawful detainer cases, contact your State Bar of California's Lawyer Referral Service line at 1-866-442-2529. There are also legal aid agencies that help tenants defend themselves in eviction cases. Some have special programs to help those affected by a home foreclosure. To find a legal aid agency, go to www.lawhelpcalifornia.org. You can learn about eviction and other rental issues in California Tenants, a guide to residential tenants and landlords' rights and responsibilities, California Department of Consumer Affairs, available at www.dca.ca.gov/publications/landlordbook. And you can find the forms you need to fill out and file on the California Courts website at www.courts.ca.gov/forms. We hope you found this video helpful. But this information may change, so be sure to research the current laws and court programs for your case. Remember, there are a lot of resources available to help you. Thank you for watching.